First thing we're going to do here is introduce you to the plan for today. We're going to give a little brief overview of our presentation, and then we're going to go through two major sections. One is going to be legal rights and obligations under a lease, and the other one is going to be the CERCA, or Canada Emergency Commercial Rent Assistance Program, which has been introduced by the Government of Canada through the Canadian Mortgage and Housing Corporation in order to help facilitate the assistance that so many small local businesses and merchants in our neighborhoods need, and then help out landlords to make sure that they have the income coming in, or some of the income coming in, that they had been counting on as part of their businesses as well. We're going to run over the program goals and summaries. We're going to talk about eligibility. We're going to talk a little bit about the required documents and materials, and then we're going to talk about the application procedure, which is pretty straightforward, luckily for all of us. And then at the very end here, we're going to talk a tiny bit about funding. That is to say, where's the money go and what do we do with it? And then we'll have some time for questions and answers. And of course, at the end of it, I will thank you all for your patience and for our partners in assisting. So first off, I do actually want to thank the City of Westmount for assisting us in making this happen. In fact, it was the City of Westmount who was the impetus behind this whole thing. They've been wonderful, and I'm really grateful for the opportunity to assist my fellow residents and business people in Westmount. If you're joining us from outside of Westmount, of course, you are welcome. You are always welcome in Westmount, and I'm sure that that you all at home watching this are also extending your gratitude to the city for making this happen. This presentation is primarily for the benefit of local businesses and for local landlords. And of course, the information that we're going to discuss today really would apply anywhere in Quebec, but it is tailored towards the local experience of Westmount merchants, small businesses, and landlords. Please do think about what we're talking about today with that in mind. I should introduce myself. My name is Matt Aronson. I am one of the lawyers here at Tedeschi Attorneys. I am a member of the Ontario Bar, and I also hold a license here to practice in Quebec as well. I'm in the process of going to a full conversion, although I'll maintain my bar membership in both provinces. I come from a real estate background. In addition to my other practice areas, which are corporate commercial law and immigration, I practice commercial real estate law here in Montreal. I have, in various other stages of my life, been a real estate broker, been a real estate asset manager. I'm currently a tenant here in Westmount, and I also am a co-owner of a building nearby and have tenants of my own. So there's a lot that I'm going to bring to this presentation that is coming from a whole bunch of different perspectives. But I do want to make sure that I say up front, and you'll hear me repeat this a lot, that this is a seminar on legal information. This is not legal advice. Everybody's situation is going to be particular to theirs, to their landlord, to their lease, to their business. And so all the information that we're going to give you today should be helpful, but I would caution you to do anything either with your landlord or independently, without making sure to speak to a competent legal professional and double checking that the scenario that you find yourself in and the decisions that you're making, you've got the best tools that you can at your disposal. If you don't already have a legal professional and you would like one, I'm going to give my contact information at the end of the seminar. Of course, I'm available to assist you. Give me a call or drop me an email with the information that we're going to give at the end of the seminar. And if there's a way for me to assist you either as a landlord or as a tenant, of course, I'd be very, very pleased to do so. So our goal here is not to solve all your problems. I wish I could. I wish I could solve all of these COVID problems from let's get the kids back into school so that we can go to work and enjoy making sure our children get educations and can play with their friends, to let's make sure that all of our seniors are well protected in the assisted living homes in which many of them are currently residing. The very little that I can do here is to help you with your lease situation, but we're not going to fix your problem today. What we're going to do is we're going to give you enough information to understand the terminology, to understand what your position might be, to ask the right questions, and to try to make a fair arrangement regarding your lease or leases in consideration of the whole COVID-19 crisis. Like I said, Section 1 is going to concern your legal rights and obligations, and this is both you and the person that you're contracted with. So if you're a tenant, we're going to talk about the landlord's rights and responsibilities as well, and vice versa. This information is really meant for everybody. And then, of course, after that, we're going to go over the Kirchhoff Program. I made up the pronunciation, so I hope I'm getting it right, but that's the acronym that's been thrown around, the CECRA, which hopefully will provide some relief for some of you. And at the end, of course, questions. I see that a few of our listeners have already posted a couple of questions. I do see them, guys, and I thank you for those. And I'm going to make sure to answer those as we go through the presentation and get to the Q&A section. If we haven't already covered it, I'm going to cover it there. But please do keep posting questions if you've got them. So the next big question is, the biggest question is the rent due as normal? We're in unusual and crazy times. Do I really need to cut a check every month to my landlord in the event that I can't operate my business? And as a landlord, do I have a right? Can I continue to collect the rents that I'm basing my whole business and planning, doing all my business planning about, even though my tenants may not be able to open their stores or their businesses? And the answer, in short, is yes. A lease, like all contracts, was an effort way back when you signed it with your landlord, or when you signed it with your tenant, to try to make certain the deal you had at that moment and project it into the future. Now, and this is why we write contracts. This is why we have agreements. So even in very unusual times like today, contracts do still have a validity in most cases, and rent being a financial obligation which doesn't necessarily get interrupted by a pandemic or an emergency is normally due under the terms of the lease. But it is like everything else in law, of course, it's nuanced. So there might be options to explore if a tenant isn't unable to meet their financial obligations because of a forced closure or because of a serious loss of revenue. We're going to talk a little bit about various options. They are not the be-all and end-all. There are others that you may discover as you think through your problem and sit with your tenant or your landlord and talk about what can be done, but we're going to cover the big ones today. The starting point for any landlord or tenant considering their rights and their obligations in the context of all these business interruptions we're suffering from is, what does the lease say? So if you don't already have a good copy of your lease to look through, I strongly suggest that you take one out, print it out, and go through it very, very carefully. If you can do that with a lawyer or a legal professional or a real estate professional, that would be well advised. But even if one isn't yet available to you, it's always good to refresh your memories to what exactly you agreed to. And there's a couple of key terms or provisions that I'm going to want you to look for, because the express terms of the lease may offer you some avenue by which to solve some of these problems. So the obligation to pay rent generally is absolute. There's no conditions on it. If you're occupying space, you're paying rent. And it is generally without any kind of expressed right to suspend it, to abate it, which is basically to discount it, to withhold it, to set it off. But it's worth confirming that the obligation is conditional on you as a tenant having access to your premises, or whether there's other things in your lease that might change the scenario slightly, such that that your landlord may be in a position where, because they couldn't fulfill all of their obligations, there may be something there that needs to be compensated. I'm not saying that it is. You've got to look at your lease and you got to talk to the other parties in order to make this happen. You got to want to check to see to see if your lease actually specifically excludes rights to do things like hold back rent or to defer it or not to pay it. And if it doesn't, then you're going to want to see if there's any conditions that may allow for a late payment or withholding or reduction. In some cases, you may have security sitting with your landlord that could be applied in times when your rent is unavailable, or you may be able to reach some other kind of arrangement. One of the things you're going to hear a lot of people talk about is how, they can't meet their lease obligations. They can't open their stores or their businesses because, well, this emergency happened, and it's what we call a force majeure. Force majeure, it's a superior force, will sometimes be addressed in a commercial lease, and leases will generally say that a force majeure or an unavoidable delay may have an impact on the lease. In Quebec, even if the lease doesn't have a provision, force majeure provisions of the Civil Code of Quebec will apply anyway. So you don't actually have to find one in the lease somewhere that says, well, if there's a huge emergency and you're unable to get into your store, then there's aspects of the lease that become either flexible or conditional. Sometimes the courts will apply these things, but all things being equal, and we'll get into this a little bit later, we don't really necessarily want to get this thing to a point where you're going to have to get a judge involved. And there's really good reasons for that beyond the logistic headache that exists today. But like I said, we're going to come to that later in the presentation. We're going to check those leases to see if there's actually some discussion of things like health emergencies or epidemics or pandemics or government orders or acts of God or things of that like. And at the same time that you're looking through your lease, I'd encourage you to take out your insurance policy. There may be business interruption insurance that's buried somewhere in your insurance policy that would allow you, if you do have to continue to make the financial obligations that you've committed to, that may allow you to make a claim to your insurance company. Now, I'm sure you can imagine, anybody who has such a policy may be fighting a bit of an uphill battle with an insurance company. We're going to get a lot of claims from a lot of people. Not all of them are going to be honored. In many cases, insurance companies may be very well motivated to find reasons why these particular clauses may not apply in the present circumstance. But nevertheless, if you paid for that insurance and there is a clause in your insurance policy that helps you, it's good to know that it's there. So take a look at those insurance policies while you're looking through your leases. Back to our lease again. Even if a force majeure clause offers you relief from performing non-financial obligations, most won't relieve a tenant from the obligation to pay rent. Even in a case where you're obligated to have continuous operation of your store, you can't just go dark. Your lease doesn't allow that. That might be something that you could say, well, force majeure, I had to go dark. Everybody went dark. Nobody was operating during the COVID-19 crisis. That wouldn't be a good reason for your landlord to terminate your lease, even if it's technically an event of default. But on the flip side, paying the rent isn't necessarily directly correlated to being open. Of course, obviously, when customers come in and they pay you for things, you take that money and use it to pay your rent. Sure, logically, that makes sense. But from the legal perspective, the obligation to continue to pay your rent isn't necessarily contingent on the reality of whether or not you're making sales. It's a tough pill to swallow, but imagine a scenario where, for whatever reason, a business person just doesn't handle their business very well. They don't advertise, they haven't staffed well, they haven't put enough goods on the shelves, and they don't have enough money to pay the rent at the end of the month. They can't very well go to their landlord and say, well, force majeure, I didn't make sales. And unfortunately, the law may look at this scenario as being similar. Nobody knows how deep your pockets might be. So the presumption is, if you've agreed to pay rent on an ongoing basis, that you're going to do everything in your power to make that happen. And of course, everybody wants to stay in business and keep going if they can. But that's why we're going to talk a little bit when we get through this section about where you might be able to find help if that money just isn't there. Now, you may have also had an obligation to close. Newer leases contain express provisions that give parties specific rights and obligations in health emergencies. Sometimes these are actually incumbent upon the landlords. Certainly landlords who have buildings or shopping centers or malls may have had to act before the government specifically listed a bunch of businesses that needed to close. And in cases like that, it is possible that if you are complying with all of the laws and government orders, either as a landlord or as a tenant, that muddies the water somewhat. So the COVID-19 forcing everybody to close does mean you have an obligation to follow those rules, especially if the lease says you have to follow government rules. And that might soften the blow somewhat when it comes to non-financial obligations in terms of operation. But it's going to be a real uphill climb to claim that because you follow the law, you can't pay your rent. So what happens then? what happens when you don't pay your rent or when your tenant doesn't pay you? And we got to start looking at this lease from the point of view of the consequences of non-payment of rent. Well, the reality is that most of us had to shut down during the last 2 or 3 months. And so many, many tenants are going to now need rent relief, either from their landlord, from a lender, from the government, from their customers. Money's got to come from somewhere. And some, unfortunately, are going to have to make the decision that they cannot continue and they need to terminate their lease. Now, many of you watching this may be feeling like they're trying to save your business. You're trying to keep your landlord from coming after rent that you don't have that's due. But some of you may be saying to yourselves, when I face reality here, we're not coming back from this. I'm too deep in the hole. I need to stop. I need to get out. And that is a decision that only you can make, and it's obviously not one you're going to make flippantly. But you should be aware that simply stopping your lease, taking your things and moving out, may not be something you can do unilaterally. The obligation that you have with your commercial landlord isn't one that is a month-by-month lease in most cases. So there may be a penalty for having done so. And that's one of the things that we need to look at and to consider when you make that business decision. Now, the Quebec Civil Code does allow tenants to avoid having their leases canceled on them if they haven't paid their rent, but not forever and not under all circumstances. Article 1883 says that if you are in a situation where you haven't paid your lease or your rent and your landlord takes you to court and really, really wants you out of that space, they want to end your lease, they want you to give back the space. But before a judgment is rendered, you pay off everything you owe, all of the rent, any kind of interest that accrues under the lease, etc. Well, at that point, the judge won't rule. Instead, they'll say, look, the debt's been settled, everybody go back to normal. Now, most well-drafted commercial leases, of course, have an exemption to Article 1883 that simply say that the parties agree not to invoke these rights, that they're waived. And you can do that under some principles of the Civil Code of Quebec. There are some that you cannot negotiate around. They're called rules of public order. But this one, unfortunately, is one that if everybody agrees that this particular rule isn't going to apply to this particular lease, if it's in your lease that 1883 doesn't apply, unfortunately, then you're not going to be able to show up at the courthouse steps and say, here's your rent, let's just call it even. In fact, in some cases, and this is something you'd want to have a legal professional look at, your landlord may have language in a lease that allows them to terminate your lease without even going to court. Now, enforcing such a right will most likely involve some branch of the judiciary. But you want to make sure that if you are finding yourself in this kind of situation, that you know exactly what your rights as a landlord or as a tenant are. And you're going to want to go back to the lease and see whether or not there's an obligation to go to court to enforce those rights. There is also the other thing we have to think about here is penalties for non-payment beyond just paying back rent and losing your space. In some leases, you might find that the landlord's in their rights to seek the court's assistance to go and end your lease and to physically remove you from your space or from the space you have leased. And they may even have some kind of penalty. Sometimes it's called accelerated rent. That's where you owe some portion of your rent, 6 months or a year, at the moment that you default. You might end up also in a situation where you have to forfeit a security deposit. Or if your landlord had asked for and you granted a personal guarantee and that thing is still valid, and you got to check because sometimes they're time limited, and it's part of your lease arrangement, in theory, your landlord may have the right to be able to come to you personally and say, look, the business owes me X, Y, and Z money, and you said you would guarantee it. The business is now over, but you're still on the hook, and I'd like to be paid, please. And under those conditions, you're going to want to make sure you know exactly what you're dealing with before any kind of push comes to shove. Now, all this to say, I don't want everybody that's listening to this who finds themselves in a difficult position to start to panic, because for both landlords and for tenants, we've got to understand that there's not going to be an easy and simple solution through the courts. Judges, first of all, do look at the law and they do look at the contracts, of course, but they're going to look at the actions of the parties as well. And judges may be reticent to invoke penalties unless the parties can show that they've acted in good faith and they've made attempts to mitigate losses. Now, this means, for example, if you're a landlord with a number of tenants who have unfortunately not been able to pay their rent, and you simply refuse to make any kind of arrangement, any kind of a deal to use the Kirchhoff program, you just sort of say, no, first of the month, I want my rent, that's it, that's all. A judge may not look very kindly on that, given the current COVID-19 crisis and the difficulties that everybody across the board is facing. Well, the same is true of tenants. If you have some money, but not enough to pay all of your rent, and your landlord is willing to cut you a deal, but you sort of say, you know what, I'm better off just keeping my money in my bank account, and we'll see what happens when and if we get before a judge. Well, a judge isn't going to like that very much either. Obviously, no one can really predict exactly what's going to happen in the courts. And this is that very fine line I need to walk as an attorney, where I don't want to start telling you what's going to happen because, let's be frank, nobody knows. But these are the things that I, as a lawyer, would be thinking about as I would advise a landlord or a tenant or both on how they should be moving forward. Let's also not forget that the courts are going to be extremely busy with landlord and tenant issues and with all sorts of other issues, especially with a backlog of 2 months that needs to be dealt with. The wheels of justice, they say, turn slowly. And that is definitely more true than ever here in the province of Quebec and during the COVID crisis. So access to a judicial intervention may take a very, very long time. And if that's the case, both the tenant and the landlord don't really have a resolution if we have to get a judge involved, where perhaps one could be reached through mutual compromise, discussion, and negotiation. And let's not forget also that litigation can be very, very expensive. And even if you do manage to win, you might not have an actionable judgment. If you're a tenant, if you're a landlord who's seeking compensation for space that was occupied by a business that simply no longer exists, you might win the judgment, but not actually be able to collect anything, since unfortunately the people that you had contracted with are no longer around, as it were. The other thing to say too, and this is not a legal point or a judicial point, but let's all remember that there's going to be vacancies, more so than usual. Those of us who grew up here in the 80s remember what it was like to walk around and see "Addaway" in 3 out of 4 signs in the windows. And nobody wants to see those days return. But I'm very much of the school that a bird in the hand is worth 2 in the bush. And if you've got a good business in your building that's just run into a little bit of trouble right now, like everybody else has, or you've got a good space that works well for your business, even if there is something that's, maybe a little cheaper somewhere else, you might be better off dealing with the tenant or with the landlord you already have, and not trying to game the system to see what, how you can maximize your gains. Because if you end up with a vacancy that you don't want in your building, or you end up having to move your business, that could end up being a lot more expensive than just making a deal. So what does that look like? Well, in cases like this, it looks a lot like compromise and communication. Communication and compromise in contracts, the 3 C's of keeping things running. Leases, like all contracts, are negotiable, and then, of course, renegotiable. If parties are willing to come together and have a meeting of the minds, there isn't anything about the relationship between a landlord and a tenant that cannot be adjusted in light of the current scenario. There are some bedrock legal obligations that any leasee owes a lessor, and vice versa. But in terms of the content of a lease, well, that is something that you can sit down and make business decisions about if you work together. But to do that, open lines of communication are essential. If realizing that you just don't have the money to pay your rent, you simply don't communicate with your landlord at all, you put them in the awful situation of having to try to guess what's going on. And if, as a landlord, you don't want to talk to your tenants and help them to know what they should expect from you, but that, again, creates a lot of unnecessary conflict. And like I said, if it ever ends up in front of a judge, you're going to want to demonstrate on both sides that you've done everything in your power to work with your partners in this lease arrangement. Neither party here is likely to get everything that they want, but it's possible that they can get all that they need, or at least close to it. But to do that, everybody's going to have to come together, put their differences aside, and sit down and figure out how to work together. Now, in order to incentivize that, the government of Canada has created this is what I'd say the biggest and most direct program for rent relief for small businesses. It's called the we're going to go to the next slide. It's called the Canada Emergency Commercial Rent Assistance Program, or CERCA for short. And the idea here is basically to help landlords offer rent relief to businesses across Canada. So having laid out all of the things that you need to think about as you decide how to go forward dealing with this problem and looking at your lease and making your business decisions, I want to tell you a little bit about some of the support or relief that might be offered to you through as a landlord or as a tenant to be able to get through these troubled times. So the Kirchhoff Program is going to be administered through the Canadian Mortgage and Housing Development Corporation. These guys are the ones who also do certification and backing of mortgages. They're gonna lend money to landlords of up to 50% of the gross rent that's owed by a tenant or tenants for what they're calling the relief period. That's April, May, and June of 2020. We haven't heard anything yet about what happens after June of 2020. But let's not forget that, as with many of these programs, they were designed for an emergency situation to stabilize the economy and keep Canadians working while we move through the worst of the COVID crisis. It is possible, although I frankly haven't heard anything one way or the other, that this program may be extended through the summer or into September. Unfortunately, I have no news on this whatsoever, and so I really couldn't say. At the moment, we're dealing with the relief period, April, May, June 2020, and the goal, like I said, is to keep as many people in their businesses and working as possible while we're all shut down. So what this looks like is a forgivable loan that's going to go to property owners who are eligible. I'm going to run through the eligibility criteria for owners now, the landlords, and then a little bit about the eligibility for tenants, because most tenants are eligible, but not absolutely all of them. And it's important, if you're going to get your hopes up about this program, to know whether or not this actually even applies to you. So what's a property owner? Well, I mean, you're collecting rent on space that you've rented to somebody else. So it's got to be a commercial real property that is occupied by what they called impacted tenants. And we're going to define impacted tenants in a minute, but it's basically people who are having serious trouble in their businesses because of COVID. A commercial real property can mean any commercial property with impacted tenants. That could be a mixed-use property where you've got stores on the bottom and apartments up top. This will only apply to the commercial portions. So if your residential tenants aren't paying rent for their own reasons, that's a different matter. Unfortunately, Kirchhoff doesn't help with that. This is really only for businesses. But it could also include something as untraditional as if you have a parking lot that you lease out to a company that uses it to park cars. No cars are coming downtown, and there's no shows at the forum, and so the guys who've been renting your parking lot from you say, look, no business, we're shut down, we can't pay your rent. Well, good news is that even though you're not a building per se, or you're a lot, you're a commercial real property, you would be eligible under this this program. The same thing would be true, for example, of in theory, if you owned agricultural land that you rented to a farmer that wasn't able to pay their rent, or if you had oh gosh, I mean, we know we can get creative and think of any other kind of commercial or property. If you got a question about this and you're not sure if what you have had is so unique and weird that it maybe doesn't apply, send me an email and I'll see what I can do to assist you. You've got to have some declared rental income from this property on your tax returns, either your personal or your corporate, from 2018 or from 2019, unless you have a new construction or a very recently purchased building where you couldn't have reported tax income because it didn't exist. You're still eligible if you entered into a lease with a tenant on or before the 1st of April 2020, and not just any tenant. It's got to be an eligible tenant, and we're going to get into who those guys are on the next slide. But here's a really important new development happened late last week. They finally announced that you don't actually need to have a mortgage on your property. If you've worked hard and gathered a lot of resources and bought a building free and clear and then rented it out as a means by which to have a passive income or as a retirement plan, you're not going to be penalized for not carrying debt. You still can apply under this program, and you can use the money that is provided by Kirchhoff to do things in addition to paying mortgages. You can also use it for paying your expenses, for cleaning, for maintenance, for taxes, for running your building in any way. So a mortgage is no longer required. And if you thought you were being bounced out because you didn't have a mortgage, not true. You can still do it even if you don't have a mortgage. Now, turning to the tenants. Who are the eligible tenants? Well, tenants are businesses, but this can include nonprofit and charitable organizations that existed before March the 1st, 2020. So let's be really clear here. If you are a landlord and you have a very new building that you just bought and you entered into a lease with a new business that was created on March 15th, 2020, and you signed a lease with them before April the 1st, 2020, you're not eligible because your tenant isn't eligible. They didn't exist before the March 1st. And because it didn't exist before March 1st, they fall into a different category. If you did exist before March 1st, 2020, and the cap here is this is for small businesses, you can't be paying more than $50,000 a month in gross rent for each of your locations. Now, for the vast majority of people looking at this seminar, $50,000 a month in gross rent is just like, it's an astronomical sum that who's charging $50,000 for a location. I mean, we're talking those ones are really, really big businesses. They've got other means of support. Kirchhoff has been limited to make sure that small businesses can have priority. And to that end, you can't have generated more than $20 million in gross annual revenues calculated on a consolidated basis, right? So if your business is actually a subsidiary of a bigger business, they want you to go all the way up to the ultimate parent level. And if you made less than 20 million in gross revenues last year, then you're eligible. If you made more than 20 million in gross annual revenues last year, the government's position on this is like, maybe, you did pretty well. Maybe you can afford to just take care of it yourself. So the other thing, of course, is that you've had to have temporarily ceased your operations, which virtually everybody has, or experienced a decline of at least 70% from your pre-COVID-19 revenues. So if you're in an essential service and you are allowed to stay open and your business was open through this last period of time, you weren't shut down, but it's been very difficult for whatever reason, you're not making the kind of revenue you used to, you still might be eligible if you're really, really suffering. And we're going to talk in a minute about how you calculate that. But just so you know, if you're actually on a sublease in your space, you're still eligible. So the government's been a bit vague about exactly how subtenants deal with this. We presume that the way that they would be treated like a tenant, and they would talk to their head leaseholder, who then talks to the ultimate landlord and gathers the information necessary to make sure that everybody gets relief. But yes, as a subtenant, you are eligible if you meet all the other criteria. So to figure out whether or not, if you're open, you've lost enough revenue to qualify under this program, and this does, by the way, count for nonprofits as well. Here's how you do it. You got to look at your revenues in the relief period, and then you're going to compare them to the same month in 2019. So you'll look at April 2019 versus April 2020, May 2019 versus May 2020, June. Well, we won't know until June, but we can kind of figure it's probably going to be it's a continuation of the same. And you look at that and sort of say, well, okay, relative to last year, we're down by 71%. Well, okay, then you're eligible. You could also, if your business isn't old enough to have data from last year, you can look at the revenues that you earned in January and February of 2020, and if they suddenly dropped off, like a cliff as soon as COVID hit, well, then you'd be eligible under this program. You should be aware that the gross revenue reduction calculation is got to be revenue that's earned from your normal activities in Canada. Using your normal accounting method, that's to say the ones you've used in the past. You can't suddenly switch accounting methods to be able to show a loss. And they exclude gross revenue from extraordinary items. So if you had been sitting on some incredibly expensive piece of equipment, which you finally said, well, we don't really need it, we're going to sell it now to make up the difference, that revenue, that doesn't count. We're talking about your normal business operations. Registered charities and nonprofits also get to do this, and they would basically just look at their revenue from last year, not counting the donations from non-arm's length people. So if your president has been throwing money into the pot to keep things going, you don't have to count that as a form of revenue. And you can choose whether or not to use money that came ultimately from the government to fund nonprofit organizations, counts in as part of your calculation or not. So if you were denied a grant this year that you would have gotten or had gotten in the past, and there you can show the loss of revenue because of government funding in the past that doesn't exist anymore, well, that's one of the helpful ways that you may be able to figure out whether you are actually qualified under this program. So, okay, so let's say your landlord says, okay, we're eligible, we can do this thing, we're gonna try to make it work. And as a tenant, you say, you know what, we are also eligible. We had to close, or we lost 70% of our revenue. Let's sit down together. Let's figure this out. How do we make an application of this kind? Well, the next thing you're going to need to do is you're going to need to meet some requirements in terms of documents and materials. The first thing is that you have to sit down with your tenant and your landlord, and you need to make and execute a rent reduction agreement for the relief period, so that the tenant's rent goes down by at least 75%. If you're the kind of landlord who is forward thinking about investing in your tenants, and you kind of say, I can afford it, and I want to reduce it to 90% off the original price, because that's going to help my tenant to recover faster, and we're going to get back to normal quicker. There's no problem with that, but it does have to be at least 75%. It also has to include a moratorium on eviction for the relief period. So at this point, we've only really got June left. You're going to have to promise that you're not going to evict the tenant because of something that happened in April or in May or in June or during that period. And you can't defer your rent or discount it, but raise the rent in the the after reference post-COVID period. That's prohibited. You're not allowed to do that. So you really do, unfortunately, have to take a haircut, as they say. God, I wish I could have a haircut. Yeah, you have to take a haircut on the money that you thought was going to come in by at least 25% in order to make this work. And no matter how creative you or your lawyers are going to get, unfortunately, there's no way to recoup that money by just pushing it down the line. So as for eligible property owners, what do you have to provide to make this happen? Well, you're going to end up having to write or to produce this agreement with your tenants. In addition to that, you need all kinds of information that you'll have to give to the Kirchhoff program. They include the property address and its type, whether it's commercial or mixed use, etc., and include the number of all of the commercial units, whether or not you're applying for those particular tenants. You're going to need to show your tax statements, your latest rent roll, and some banking information, including your bank statement. So, there's some information here that if you didn't have to give it up, you probably wouldn't be waving it around, showing people in the government what's happening in your bank account. But in order to make this work, unfortunately, they are going to ask for a copy of a bank statement. You're going to need ownership information and contact details for all the owners. So if you have some partners in your building and you're the managing partner, you handle everything for other people, but they have an ownership right. They're listed as owners, and you're going to have to tell the government who they are and how to reach those folks. And then you're going to need a declaration or attestation for each of the small business tenants that requires or requests financial assistance. Unfortunately, there's just no way to do this as a blanket application that covers all your tenants in the building. Somebody had asked a question earlier if the landlord can pick and choose which tenant it offers the program to. Yes, it would appear that that is the case. It's unfortunate that we're going to have to rely on the goodwill of tenants and landlords to work together to make this happen. So if there's a tenant who is very reluctant and does not want to enter into an agreement of this kind, or a landlord who, for whatever reason, is willing to offer it to some tenants but not to others, yeah, unfortunately, that flies under the program at this time. I would hope, though, that if it works for one tenant, it would work for all the tenants that a landlord wishes to assist in keeping them in business and keeping them paying rent. Just a word to the wise for the owners. If after you receive your Kirchhoff money, you restructure, you reorganize, you dissolve your business, you go bankrupt, God forbid, you're still going to have to pay back that Kirchhoff loan. If you default on the repayment of that loan, well, the CMHC does have recourse to come and get that Kirchhoff funding from you. That's shouldn't really be a problem though, because if you follow these rules and you forgive the rent, then actually these are forgivable loans. They're never going to collect them. The 50% of the gross rent that Kirchhoff is going to kick in to landlords, well, you're going to get to keep that money so long as you meet the program requirements that we've laid out now. You're not going to suddenly evict somebody who wasn't supposed to be evicted, or attempt to go and raise the rent in contradiction to the contract or the to the lease after this COVID crisis has passed. So if you play by the rules, you're going to get rewarded, and you're going to get 50% of that rent that you were entitled to before COVID hit. As we discussed, you'd had to have lowered the rent by at least 75% for your tenant. So your tenant is going to be kicking in up to 25%. The government will give you up to 50%. And that other 25%, well, that unfortunately, that's going to be coming out of your coffers. That's why everybody wins a little bit here, but no one wins everything. Tenants are going to have to participate. You're going to have to give some things over to your landlord as well. Obviously your contact information, your registered business name, not the one you're operating on under. The sign on the street might say one thing, but if you're a numbered company or you're using a trade name, you're going to have to make sure your landlord knows about that and is provided the correct information so that they can make this application. You're going to have to make sure that you check your lease to figure out exactly what your square footage or your lease area is. And of course, you as a tenant will have to confirm the gross monthly rent for this reference period so that everybody is, or for this relief period, so that everybody's on the same page as to what was due. Then, of course, the attestation that we discussed earlier, that declaration that your landlord will be producing and giving to the government, well, you do need to provide that to your landlord. So you'll have to sign some documents indicating that you really do need this assistance. And that might include the calculation and proof of your loss of revenue over the COVID-19 period. I should note that we are at 4 o'clock now. We were actually supposed to stop now, but because of our technical problems, we're going to just keep going. For those of you who had booked off only an hour for this presentation and need to leave now, we've put up a link to these slides that you can download as a PDF. At the very end of it, you'll find my contact information. So if you have additional questions that didn't get addressed and you do need to leave, feel free to drop me an email or even give me a call at the office, and I'd be happy to assist you if I can. If you're sticking with me, though, let's get through this quickly so we can get to some questions and answers. The application period actually opens today. We scheduled this seminar before we knew exactly when it would be happening, but it's today, May 25th. Today is the first day that you could apply for this relief program. But you can apply right up to August 31st. So even if you're in a situation where you cannot reach an agreement, or we don't really know what's going to happen right through this whole reference period, and it's only in August that you make a deal and figure it out, that's okay. Anytime before September 1st, you can make an application like this. Like all of the other government programs, there is a concern that the government is going to just be overwhelmed by applications. And so they've asked us to apply on certain days. So Quebec landlords, which all of us here in Westmount would be with Quebec landlords, with up to 10 impacted tenants can apply on Mondays or on Fridays. And Quebec landlords with more than impacted tenants, and that's to say making an application that includes more than 10 people at once, or 10 businesses at once, those have to be done on Thursdays or Fridays. So Fridays are free for all. It's going to be a very, very busy day because anybody across the country, no matter where they are or what they can do, can apply on a Friday. I would recommend using either Mondays or Thursdays if you want to reduce the amount of waiting that you end up with and the amount of bureaucratic friction that you're likely to run into. The application itself can be made through the Canada Mortgage and Housing Corporation website, which I've indicated here, but it's just a random bunch of letters and some tiré in the middle there. My recommendation is, if you don't have this written down already, just Google it. It'll come up. Or email me, and I'll put you in touch with them. And that's pretty much everything we had for this end of the presentation. Before I do get into the questions that have been posted, by the way, There's another one of these presentations that's going to be on Thursday. By then, hopefully, we'll have all our technical issues sorted out. That one is specifically about how businesses can get assistance and aid from the federal, provincial, and local governments. There's a lot of material there that might help your business if you are needing additional aid on top of and beyond Kirka money for rent relief. And I encourage you to please come and participate in that one too. You can use the same method you got this link to get that one. Simply email the mayor's office, and they're going to tell you exactly when and where you should meet me on Thursday. So we had a couple of questions here I'd like to address. I'm going to just go in the order in which they came in. So somebody asked, can a landlord pick and choose which tenants it offers the program to? And as I said, yes, it appears that they can. If your landlord isn't able to make a deal with you, or you're not able to make a deal with the landlord, then you can't really apply. And there are all kinds of reasons why a landlord won't be able, or couldn't, or wouldn't want to make a deal with a certain tenant. There is no enforcement mechanism by which the Kirka program can be forced on a landlord for a particular tenant. That said, let's not forget that things we talked about earlier about mitigation and the obligation for, or at least the desired behavior that judges like to see in landlords, where, if ever you end up before a judge and explain to the judge that you are ready, willing, and able to enter into a rent relief deal, you had paperwork prepared, you were in communication with your landlord, and they just refused to help you while also helping other tenants, that's not going to look great. And so this isn't exactly a legal argument that I can make in court, but it certainly would make it harder for the landlord to come to court and do what we call coming with clean hands, demonstrating that they've done everything in their power to assist, and therefore they're entitled to collect whatever damages they are given under the lease, because they've done everything they can do to prevent this problem from happening. So another person asked, my landlord doesn't want to do this. How do we proceed? That's a really tough position to be in, because so far as I can tell, as a small landlord and real estate professional myself, it's hard for me to understand why a landlord wouldn't want to participate in this program. Obviously, anybody who gets into the business of renting out space wants as much rent for it as they can possibly get. And if they had a lease that entitled them to $100 a month, it becomes psychologically difficult to accept only $75 a month when you're entitled under the contract to 100. On the flip side, however, you can't get blood from a stone. And once a tenant is no longer in business, they're no longer paying you anything. And vacancies in Montreal in pre-COVID times could range between a couple, 3, 4, 5, up to 18 months. And so it may not necessarily be in a landlord's best interest, when they think about it, to not proceed with this. That said, in order to participate in this program, you really do have to have a dance partner. So if you are facing a one-sided situation, it would be a good idea to sit down with a legal professional, look over your options, and make the best business decision that you can make for yourself. And that may include looking at the hard reality of moving your business to another location, and getting into a litigation scenario, or at least an uncomfortable negotiation with your former landlord. Let's hope it doesn't come to that kind of thing. We had another question that came in. I just got to scroll down to be able to see it here. Came in, it was a good question. This listener said, governments have announced that malls outside of Montreal may open on June the 1st. When can office buildings in Montreal open? Great question. I wish I could tell you. I have no idea. The situation is evolving and ongoing. And as you know, the Premier is giving updated information with respect to openings daily. There is a list of businesses that can open available through the government's websites. Again, if you email me, I can send you the link. You're going to want to make sure, as anxious as you may be to reopen, that you do not do so until you are legally allowed to, as you may face some serious penalties and consequences. That said, I think that I think that the government and office workers are all eager to get back to work. Today is my first day back in my office since COVID started. I'm a lawyer, so I'm classified as essential services. I could be have come in, but I chose not to for my own and my colleagues' safety. But it is, I must admit, very nice to get back to some semblance of normal. So that's about it for the questions. As we were doing this, the senior partner of our firm, Ken Adesky, had been listening in the other room and came up with a really great suggestion. You know, he said, if you have the money and you want to do this Kirchhoff program, you may want to pay at least 25% of your rent so that you can demonstrate that you're acting in good faith, even in a scenario where your landlord ultimately doesn't make a deal. That said, or additional to that, if you've already paid rent for April, May, and June, and you are able to make a deal with your landlord to be able to do the Kirchhoff program, that money that you've already paid is supposed to be either refunded to you or used as a credit towards future months of rent. Landlords can't double dip, obviously. They can't take the money from you and then give you a rent payment for like just June and then take Kirchhoff money for April, May, and June. So, you know, again, everybody's got to act in good faith. And so if you were to sit down or call us and say, can you write me a letter explaining what this 25% of the rent is about and inviting my landlord to come to the table, etc., you're doing it obviously to keep the open lines of communication, of course, but you're also doing it to make sure that you have demonstrated that you're doing absolutely everything that you can do as a tenant to minimize the impact on your landlord while also asking for assistance. I'm looking now in the thread here to see if there's any other questions, and I don't see any. So as interesting as staring at my face must be to all of you, I know my spouse really loves doing this. I'm going to wrap it up in a few minutes. If you have any further questions, pop them in now while I go to my last slide. So, in conclusion, first off, I got to thank the team at the City of Westmount for making this presentation possible. That's my local councillor, one of our best, Councillor Ludham, was the one who arranged for me to be here today. Mayor Smith and her office, and the Director Benoit Herbichois was essential in this putting together this presentation, and in particular, I owe some thanks to Sebastian Samuels, who was the IT guy who made the magic happen here. We ran into a rough spot at the very beginning, but he sorted it out, and without him, there's no way that I could be reaching you wherever you are today via this amazing YouTube/Zoom and PowerPoint creation that we've created here. My name is Matt Aronson. I am an attorney at Adesky Attorneys. You can reach me at matt@adesky.com. My phone number is 514-288-8070. I'm at extension 126. If you need assistance in this or any other commercial or real estate endeavor, or just for the sake of it, I might as well tell you, I do immigration as well. If you've got an immigration matter that needs to be addressed, I invite you to give us a call. Either I or one of the associates here would be very, very happy to assist you in any way that we can. And when we are able to see each other face to face, I invite you to come and visit our offices in Westmount. We're in the Toulon building at 4060 St. Catherine Street West, just opposite kitty corner from Tavern on the Green. Or on the Square, Tavern on the Square. That's everything I've got for you guys today. I thank you very much for letting me into your screen and your ears, and I hope this has been helpful. Have a good day.